we did do something. If you go back to the timeline of requests, after those decisions came out, we asked that his rights be respected.
But the whole point of the U.S. courts was that they weren't being respected, yes. And the U.S. courts were attempting to do something about it. So you're leaving somebody to seek a remedy in a situation where the courts themselves have said no effective remedy is being offered.
Right, and so the result of those U.S. decisions is that you do have access to habeas corpus review, and Mr. Cotter availed himself of it more than once on the materials he's put before you. If you're asking me, in effect, don't you have to give something else for participation, Canada's participation that you found in 2008? If we get back to the point that that's the breach that we're talking about here, we say that he's already received the responsive remedies to that. Because if the violation is participation, the responsive remedies to me are stop participating, or at least stop participating in that process until you've satisfied yourself that it's been fixed. And that was effectively imposed by Justice von Finkenstein in 2005 when he issued an interim injunction to stop us from doing any further interviews. The other remedy that would be responsive to participation is give up the fruits that you obtained as a result of that participation. But he's already got that remedy from you in 2008.
But my point was that I think the argument goes beyond participation. It is the fact that somebody is detained in conditions declared illegal, and part of the illegality was that there were no enforceable remedies or effectual remedies. And it is having a citizen incarcerated abroad under those circumstances that is complained about.
Yes.
Whether you participate or not.
Yes, and so now, but this is part of the problem in my submission with respect to the remedy that is imposed below. That is the state in 2003. We're giving a remedy in 2009 that fails to reflect that the system has been fixed. So in my respectful submission, you have to look at that in terms of what's happened over the passage of time in determining if that's the breach that we're talking about, whether a remedy that assumes we're still back in 2003 is an appropriate and just one.
Well, it's certainly not conceded that it's been fixed. I mean, that is a matter of high controversy as to whether it's been fixed. And if there is a question in that respect, ought the government not to err on the side of extricating somebody from what was declared by the U.S. courts to be an illegal regime?
Well, that again, the government has done what it chose to do, which is to insist on respect for his human, properly constituted trial court and a number of other things. So that's what the government chose to do. The claim that's made is you've got to extricate him because what? We're going to sit in judgment of whether the U.S. courts provide sufficient remedies for any of the harms that Mr. Cotter says he's suffered? That's not your role in my respectful submission.
Could we say that the breach, rather than limiting it the way you've limited it, is it fair to characterize the breach as the refusal to request the return in the face of this context? What you're saying?
Well, yes, I say that is. But
the charter breach.
The charter breach that he's aimed at is the refusal to make the request. But again, you only get to a breach if there's a duty to make the request. And again, you can't get there in international law. No other court has said you can get there as a matter of constitutional interpretation. And in my respectful submission, you just can't say there's a breach of the sort that justifies the remedy that the courts imposed below.
Are we confusing the duty to make a request or the unreasonableness of not making a request and, on the other hand, the right of the U.S. to refuse that request? So you said earlier, what must seem to be long ago in your submissions, that there is a reasonable explanation for the refusal of Canada to request the repatriation of Mr. Khadr. And that explanation is that Canada does not want to interfere in the process in the U.S.
Yes.
Well, that might be a reason for the U.S. to refuse Canada's request. Should the request be made, the U.S. would then determine whether, in the face of all the circumstances of which it is aware, plus the request by Canada to have this citizen returned to Canada, the proceedings in the U.S. ought to continue or not.
I say we're not making that sort of confusion at all. What's being said here is that by operation of law, we have to make that request because there's been a charter breach, because of Canadian government action. If you get that far and make the request, in my respectful submission, that request is incoherent to the U.S. because the U.S. looks at that request and says, because Canadian officials blundered, we have to be denied our opportunity to try him on serious charges.
Again, limiting it in your response to the blunder, in quotes, of 2004. As Justice Binney explained, that may be an overly narrow view of the claim.
But to get there, you would have to conclude that, make a conclusion that the current system does not allow him to have a fair trial. And in my submission, you're in no position to make that. And in fact, he can make that claim himself at the trial. So there is a court of competent jurisdiction. I take you back to 5 in 2008. The ultimate process may be beyond this court's jurisdiction and control. It is, in my submission. And what is being sought here is an attempt to get that trial remedy. A stay of proceedings is what is being sought here. And in my submission, whether it's direct or indirect, it's still wrong.
You're saying that it's a stay of proceeding, but isn't there some kind of midway? And I understand that we're now into the substantive outcome, but wasn't there other response that the government could have given, like, we will undertake to surrender Mr. Khadr whenever you will need him for purposes of trial? So I'm not sure that I'm following you when you say that what's in fact requested here is simply a blunt stay of proceedings.
Well, it is a request to terminate proceedings, because when your case is Canada has been complicit in torture, bring him back, it's not like you're going to bring him back to a trial in Canada. I agree with you that there's a range of things the government could have done, and the government showed over the course of time that it was willing to do a range of things. It drew a line. Yeah. The fact that it has other things that it can do at its disposal is a good thing. That's diplomacy.
Thank you, Mr. Frater.
Thank you.